Burkhard Schafer talk. So Burkhard Schafer is professor of computational legal theory at the University of Edinburgh. He's co-founder and currently director of the Script Center for IT and IP Law, where his work covers all aspects of technology regulation. He's also a member of the expert group AI for People, which is a cross-border initiative chairing the working group on an ethics framework for legal technology. Please, Professor Burkhard, you have the floor now.
Thank you very much, and thanks a lot also from me for your kind invitation and this excellent event. I'm indeed going to talk a little bit in the next 20 minutes or so about the work we've done with AI for People, but also with the new research network on trusted autonomous systems. And I'm going to share my screen in a second. Okay. And start time. So, one of the remarkable things, and veterans like Adam and Monica, I think, will agree with that, is that over the last couple of years, the uptake of legal tech and legal AI has accelerated massively. For a very long time, it was a sort of niche interest primarily for academics. There were a number of success stories, but the sort of broad acceptance by the legal community was something we always aimed for, but were difficult to realize. And now it looks indeed as if the availability of AI tools is going to change the way legal services are delivered. This is a chart from a study carried out by the Law Society of England and Wales, simply trying to quantify what impact already now technology has on the job market for lawyers. And it does seem, even though these have to be taken with a grain of salt, that there is a markable, quantifiable impact now that, for instance, jobs are not created in the same speed that they had been in the past. And that poses a challenge for law societies, for regulatory bodies in particular, on how to respond to that development. One of the things we did in Scotland, for instance, is to create a new accreditation of legal technologist, someone who specializes in legal technology. And for the first time, this accreditation by the Law Society is available both for lawyers, but also for non-lawyers, for IT specialists working in a law environment. And part of the reason for that is to ensure that citizens get services that are up to scratch, that there's a regulatory environment created that protects all citizens who are the subject of these developments. Historically speaking, always was for a very long time a regulated profession, and that included specific ethics guidelines and regulations to which you have to abide to when you are. Software design, software development is not a regulated profession, and that, I think, does create a number of concerns if we are talking about the widespread adoption in practice. So that these are green shoots of trying to re-establish a degree of regulatory control. Now, Atomium, the European Institute for Science, Media and Democracy, has over the last 3 years run a couple of expert hearings and expert committees trying to develop a framework for the ethical use of AI. I was part of all three. In the first incarnation, the first iteration was shared by Luciano Floridi, whom you can see there on the right, and it tried to come up with some very general principles of AI for a good AI society. The second iteration, chaired by Ugo Pagallo, was concerned with a more analytical, slightly more in-depth analysis of the risks. And we are now in a sort of third iteration that looked at ethical rules for specific domains. So the first two reports that we did addressed AI in general. The next round identified 7 sectors that are particularly affected by AI, and that includes law, and I was chairing that specific stream. You can already find the reports from 4 of these streams on the website of Atomium. Unfortunately, not yet the one for law. We were a little bit late. The complexity of our task was greater than we had anticipated. So we are going to present our report in October to a meeting, hopefully. It will then be available also from this website. It also means that I can't give you yet any information about the final report. That would be unfair to our sponsors, but I will base my talk on the work that we presented for the first time in December in an open meeting in Brussels. So there will still be some changes between what I've presented today and the final report when it is given officially to the Commission. These studies already have informed policy initiatives. They informed and were quoted by the high-level expert group on AI by the European Commission, and they also found their way to a certain extent in the proposed new rules on EU regulation on AI that was published a couple of two weeks ago. So some of these ideas are now turned into a regulatory framework, and that is already for me both a delight but also a problem, because it raises for us the old philosophical question of the relation between ethics and law. These things now become law. Are they still an ethical guidance? And principally, I would say, and we have to be very careful, I think, in this space, ethics is not a replacement for regulation. Ethics starts when you have already achieved compliance, and that includes data protection law compliance, but also other duties such as the public sector equality duty. So some of the issues that Monica raised in her excellent talk about the black box society, the danger that we are getting biased AI decisions, for me, that is not even an ethical question. That is a strict legal question. These things are illegal. And that is very much how the European Commission proposal also treats them. Ethics starts when this compliance has been achieved, when we want to go above and beyond the call of duty. So that is important to remember. Having said all that, the legal profession is special because for the lawyer, ethics gets teeth. Most lawyers are regulated by their professional bodies. They typically have ethics guidelines, and if you violate these, you can get debarred and excluded from your job in extreme cases. So here we have a sort of in-between model of governance, which is not quite legal regulation, which is not quite just soft ethics guidelines, but professional ethics standards that have a degree of self-enforcement attached with them. And my hope would indeed be that some of our proposals for AI ethics in the law find their way into these professional standards. We came up with around 20 principles, and I won't be able to talk you through all of them, but that one here follows in a way directly from that idea. Making the decision to choose a AI tool is in itself an exercise of professional judgment. And therefore, as members of a profession, lawyers have a particular ethical duty to make that choice responsibly. They have to know what they are doing, just as they have to know this with any other tool. So ignorance is not an excuse if you choose as a lawyer to avail yourself of a tool that then makes a mistake, saying, I didn't know, I couldn't anticipate that, no one told me, it was all complex technology for me, is just not good enough. It also means that as lawyers in a professional organization, we have duties that go beyond the interaction with an individual client. Lawyers are also officers of the court. Their professional bodies take on specific responsibility for the well-being of the legal system as a whole. And that also has ethical consequences. It means in particular that the ethically sound use of AI is a collective responsibility, not just an individual responsibility. And one concrete recommendation for that is, for instance, to have a system in which lawyers can share experience about problems, where there is a systematic whistleblower infrastructure, just as we have in a way with drugs and medical products, so that errors can easily be spotted and encountered. That is indeed one of the recommendations that you also find in the EU regulation for AI, that we need a robust system where people can own up to their mistakes and allow others to benefit from them. There's always a danger to be fascinated by a modern technology. And one of the things that always struck me is firstly that some of the types of technology that we are now talking about have been around ever since I got interested in the field, and that was back in the 1990s. And some of the ethical problems that we now encounter also are quite old. They are not new problems. And a case study I often refer to in this case is one of fully automated legal decision making, which in the UK was introduced in 1998, so quite some time ago, in the Social Security Act. The Social Security Act allowed fully automated decision making about social benefit applications, a strictly example of symbolic legal AI. The Security Act is represented as essentially a prologue program. The expectation was it makes decisions faster, cheaper, and potentially also fairer. And if we look at the debate at the time in Parliament, which was very controversial, we already can identify some of the recurrent ethical questions that are still very much with us today, and I think a perennial ethical question. The first one is, how do we know that the decision is right? Is there a problem of the black box society that Monica mentioned? And if it is not right, how can we contest the wrong decisions? What are the remedies? If I develop a tool, I take on a responsibility for when it goes wrong, so I also have to think about potential remedies in that case. So that is one set of problems. Can we make sure these things work? The second one was, even if they can prove that they are correct, even if we have a formal proof of that verifies certain types of characteristics we are interested in, how can they be explained to the claimant and also to the wider society? Now, what Monica was talking about in terms of the black box society covers parts of it, but only parts of it. Explanation in law goes beyond showing how a system worked objectively. It has to take into account what the function of that explanation is. We owe ethically a duty of explanation to a defendant in a criminal trial, which is very different from one in a civil litigation. We owe a duty to explain the law to wider society. Court decisions have multiple social functions, and we have to ask ourselves, how does this task to explain and to educate, even if the system is provably correct, survive when we move to technology? And then there was a third discussion at the time in Parliament, and that is for me in a way the most interesting one. Even if we assume that we can prove that the AI works correctly and replicates faithfully what a human lawyer would be doing, and even if it was able to also explain that decision in an appropriate way, is it ethical to use it? And parliamentarians at the time were not sure about that, not at all. And the concern they had was to say, what symbolic message does it send out to the most vulnerable people in our society? People who apply for social benefit, who very often are already at the margins, are already facing exclusion, if we tell them, we are not even interested enough in your story to give you a human to tell it to. Here's a form, fill it in, it will automatically calculate what you are owed, then you get your money. Then you should be happy, shouldn't you? And I think some parliamentarians quite rightly said it's not that easy. Using this on one particularly vulnerable group and only that group is also sending a symbolic message. Being faster, being cheaper are important characteristics, but we also have to take into account the psychological impact that this has on humans and the wider social impact and our understanding of human dignity. If you look at the discussion today, and also I would say the contribution the AI and Law Society has made to it, I would say the first one was always with us. and always a key theme in AI and law, and we have made definite progress there. The second one is a big topic at the moment, and yes, there are technological answers to this. Interpretable AI, explainable AI is a hot topic, but these are all technical problems and technical solutions. I think we've shied away very often from the harder questions, the questions that do not have obvious technical solutions that question number 3 encompasses. What is the wider social message that we are sending out if we automatize legal decision making? So we came up with 20 principles and might even have more. And as I said, I won't be able to mention them all. But the important underlying philosophy was that law is special. Law has a specific type of importance for our life that other fields where we might think about automation don't. It is constitutive for our society. We want to live in a democracy under the rule of law. And the rule of law ideal is not just a technique. It creates a specific type of collective identity, evolves over a long time, and its practices and forms are imbued with social meaning. There is a reason why our judges wear fancy dress, like the one in the picture above. It sends a specific type of symbolic message that is important for the dignity of the justice system. The image below, that is the famous Miller von Sanssouci, a simple miller who challenged Frederick the Great and said, as long as there are courts in this country, I can have my mill and you can't take it away from me. And that type of story creates identity. It allows a democracy, a country, to explain what it is. And we have to be really, really careful what we do with this type of social meaning when we replace it by machines. So we tried in these 20 principles to capture some of the opportunities for AI, for better justice and for the rule of law, but also some of the risks. What we want is a 360-degree assessment of the impact that AI has on the integrity of the legal system and of its values, both the ones that are obvious and the ones that are maybe less obvious. And yeah, simply because of time, I'm just going to talk very little bit about some of them. One of the interesting things about law and legal AI is that sometimes systems that work well for your client and even well for the state at a given point in time can have in the long run problematic and undesirable ethical consequences. Take an AI that predicts the likelihood to win a case. That can be really beneficial if it works well, because your client won't litigate if it's unnecessary, they won't spend money, they won't lose money, they don't lose their time and effort. So it might be of benefit for your client to have a better assessment of the chances to win a case. It works also for the justice system. It reduces costs, it reduces frivolous litigation. These are good things, and they definitely count from an ethical perspective. But in the long run, there are concerns and dangers associated with this. It might mean that certain types of cases aren't heard any longer. And Adam, in his talk about argumentation schemes, he mentioned one of the problems in law is that the law sometimes changes. Precedents are overturned. Laws are changed as a response of social pressure. And very, very often, the reason for that is that someone took on a case that looked totally hopeless and nonetheless won it against the odds. Some of the most important changes that we have in the law came from unexpected cases by our Supreme Court, by the constitutional courts. Would they still happen if an AI says you have no chance of winning? Would they happen if a legal aid board uses this technology to say, if you only have that low a chance, we are not going to fund you? So even though it might benefit your individual concrete client in front of you, and even if it might benefit the legal system at this point in time, there might still be a cost for the long-term legal system and for the common good in living lawfully, because we are ossifying potentially our legal system. So we need a way to account of these long-term dangers just as much as we need to be able to ascertain the correctness of the system as it is now. And that brings me to the second most important principle, and probably the only one that we will have time to discuss. Legal technology is shaped in context with significant power imbalances. And that means in particular that the responsible development and employment of AI reflects these structural conditions and protects against unfair redistribution of risk and benefits. And ideally, AI in law should aim to reduce existing power imbalances. One key theme of the legal AI community always was access to law, facilitating access to law, making it more accessible to ordinary citizens. And that is a challenge to power, potentially. But as AI becomes more important and more successful, we are also facing the danger that new data silos are created, walled gardens, that the law of the future is owned by LexisNexis and Westlaw or Thomson Reuters, because they are in charge of the AI retrieval tools that some of the speakers already mentioned, because they generate or they own through copyright quite a bit of the data that trains these models and makes them feasible. So potentially we have to be very, very careful that the potential for AI to create a fairer society and a better access to justice does not in reality have the opposite effect, because it creates new ownership structures for legal data. We talked a little bit about natural language processing also in the first talk, the overview talk. Here too, we can quickly start to think about power and power imbalances. Language is still a significant barrier for the access to justice for many. Legal language is complicated. Can we use AI to make it more accessible, to translate authoritatively into easier grammatical structures? But if we do that, is it good enough to follow or to work with languages for which we have robust language models because there are lots of speakers? If you're an English speaker or a Spanish speaker or a Chinese speaker, there will be lots of people who work in that field and might develop tools for you. If you're a speaker of a minority language, Gaelic, Scots, for instance, or in one of the indigenous languages in the South Americas, will there be similar tools available? I think ethical legal AI has to take these structural concerns into account and cater for them. So we should not just do what is easy for us and cheap for us and what everyone else is doing because there is a market for it. We should lobby for, and we should be engaged and give a voice to attempts to use the full potential of legal technology in that way. So as I said, I won't have time to go through the other principles at this point, but it gives you hopefully a flavor of what we tried to do with AI for people. We tried to find a way to evaluate the legal balance of technology in the justice system that goes beyond what we have been doing in the past. And that was primarily to try to make sure that systems are correct, that they give reasons, that they are unbiased, things that are relatively easy to address with technological solutions, and instead open the discourse to those things that were already raised back in the 1990s, the wider social impact and the significance that automation can have for our justice system. And yes, the other 18 principles you will be able to read from October onwards, hopefully, on the AI for People website. Thank you.
Thank you very much, Burkhard. We have a question from the audience, which is in the AI for People group, you have selected some sectors for a particular attention and for developing a work or paper on that. And the question is, what are the most critical sectors in the opinion of the AI for People group, or in your opinion, and why? This is the question. Yep. What are the most critical sectors and why?
Mm-hmm. Well, there's a reason I volunteered to chair the legal stream. I do think the legal stream is one of the most important ones and one of the most risky ones as well. If the rule of law fails, then our societies face a massive problem. And I think we've seen over the last couple of years that we can't take the rule of law for granted. We have seen in seemingly mature and stable democracies how politicians were able to bend the rule of law in ways that no one could have anticipated, I think, 10 years ago. So I think this is a precarious public resource that needs protecting. And for me, that's why I think it matters here in particular. And that's why I brought the example back from 1996, which I think was a good discussion to realize the way we treat the most vulnerable in our society, how social benefit law works, how a whole range of legal provisions works. That is absolutely crucial for a just society, and we have to be very, very careful how we do this. The second important one is in the financial sector. Obviously, there are concerns that quite a number of the problems that we faced in the financial sector, including the 2008 crash, were at least partly caused by inadvised use of technology. High frequency trading, using algorithms for risk modeling when no human any longer understands these risk models. That again creates risks for all of us. Again, if our finance system crumbles, if the banking system fails, I don't think our societies can any longer cope with that. So these two on the civilian side were for me the most important, and they were two of the seven themes that were discussed by the panel.
Thank you. We have another question here, which is if AI may reduce frivolous litigation, and what might be ethical concerns about that?
Yeah, I mean, as I said, I mean, it's helping people to plan better whether they should sue is in principle a good idea. And I don't want to take anything away from these approaches that got quite a bit of press that try to predict the outcome of cases. So there's definitely a plus there. The only question is it enough to now stop and say, well, that's obvious then, we don't have to worry any longer. And I don't think it is. And I try to give a little bit of the reason in the talk, but I can illustrate it through an example. Back in, I think, 1996, if you had asked a lawyer, a judge, a legal academic in Scotland, can a husband rape his wife? They would all have said no. They would have said there is a institutional writer, Lord Hume, who said it is not a competent charge. There are at least 3 high-level precedents that have reaffirmed that principle. Look, in any textbook of Scots criminal law, it will tell you there is no rape within marriage. The prosecutor at the time, like Procurator Fiscal, nonetheless brought an action against Stallard on the grounds of having raped his wife. Any human lawyer on the eve of the trial would have said, you made a mistake. That's crazy. You have no chance in hell. This is totally frivolous. You are wasting the court's time. But he said, no, actually, I think there is something going on in our society. I'm sensing here a shift in mood. I think I can convince the court to deviate from past precedents. And he took that risk. And lo and behold, he was successful. And he changed the law through one momentous case. If you had asked a human lawyer, they would have said no chance. If you now use these human lawyers to train the AI or to validate the AI will give you the same answer. It will say no chance. So far, that is still not bad, because you can simply treat it as one other piece of advice as you would treat the advice from another human lawyer. But if you then start to trust the AI more, because it's an AI, it's a computer, it can't make mistakes, then you have a problem, because then you stop taking that long shot. Or even worse, if it is used by low-ranking bureaucrats to decide on funding. That's my concern about it being used by legal aid boards. they will simply say, no, sorry, this is not worth public money. The AI says you have no chance, we are not going to fund you. So if that system had been in place, we risk that this type of landmark decisions, the decisions that deviate from the past, that change the trajectory in response to social needs, are not heard any longer, because the AI lacks this sort of social context. One key assumption behind machine learning is the past is a reliable guide to the future. Often it is. In law, we have the principle of binding precedents because of that. We want stability as well, but it's not the whole story. Sometimes the past becomes an albatross around our necks. And there's a real danger that AI takes away the flexibility or limits, reduces the flexibility that we also need in our legal system.
Well, thank you very much, Burkhard. We are already ahead of time, unfortunately, because I really was having a lot of fun, and I had today. And I would like to thank all the participants, and I'd like to thank Professor Burkhard Schafer, Professor Monica Palmirani, Professor Enrico Francesconi, and Professor Adam Weiner for their brilliant talks. This was meant to be an introductory event, preparatory for our main event this year here in Brazil, which is the ICAIL from June the 21st to June the 25th. And so I hope that the participants here will also join to check out what is going on in the mainstream of these different fields from which we had today the main experts in their particular area of knowledge. And so I would like to thank again our sponsors, Jus Brasil, Legal Code, Logarithm, and Urbano Vitalino Advogados. And I hope to see you all in the ICAIL conference in the end of June. Thank you very much, and see you.